All right, today we're cracking open the legal rulebook to talk about one of the most powerful and sometimes controversial tools in a trial, the admission. You know, that moment when a person's own words, said long before they ever saw a courtroom, come back to haunt them.
So just imagine a high-stakes criminal trial for a second. The prosecution's absolute best piece of evidence isn't a smoking gun. It's something the defendant casually said to a friend months ago. How on earth does a court handle that? This is a huge challenge, and it gets right to the heart of a constant tug-of-war in our legal system, the search for truth versus the rules of fairness. At the core of this whole thing are two ideas that are constantly bumping up against each other. On one side, you've got the hearsay rule. This is a big one. It generally bans all that he said, she said stuff. You can't just have witnesses repeating things they heard from other people. But on the other side, there's this massive, powerful exception to that rule called an admission, and that's what we're diving into. This special pass that gets handed to a statement just because it was made by someone in the case, and, well, it makes them look bad. Okay, so let's get specific. What actually is an admission in the eyes of the law? Because let me tell you, it's a lot more than just saying something you wish you could take back.
The official legal definition is pretty precise, but in simple terms, it's any statement you made in the past that now hurts your own case. Let's say you're in a car accident lawsuit. If you told your friend right after the crash, "Man, I was definitely speeding," well, that statement is now completely against your interest in winning. And boom, that's an admission.
But here's where it gets really interesting. An admission isn't always about what you say. Sometimes it's all about what you do. The law is smart enough to recognize that your actions can be a statement all by themselves.
This whole idea is called admission by conduct, and it makes a ton of sense, right? I mean, think about it. Fleeing the scene of a crime, shredding a bunch of documents, lying to the police. The big question the law asks is, why would an innocent person do any of those things? These actions are treated as evidence of a consciousness of guilt. It's like your actions are confessing something that your words never would.
Okay, so we figured out what an admission is, but how does it make the journey from a casual conversation or maybe a tense police interview all the way into the courtroom so a jury can hear it? There's a very clear path it has to follow.
So how does this stuff get past that big wall called the hearsay rule? Well, there's a special rule that basically acts like a master key. It just flat out says that the hearsay ban does not apply to admissions. And just like that, this one little rule unlocks the door and lets this incredibly powerful evidence into the trial.
But hold on, it's not a total free-for-all. There's a big catch, and it's called the first-hand proof rule. What this means is you can't have layers of hearsay. A witness can't get on the stand and say, "Well, Bob told me that Sarah confessed." No way. The witness has to be Bob, the person who actually heard the confession with his own ears. The evidence has to come straight from the source, or it has to be written down in a document.
And you know what? Context is absolutely everything. The law is very clear that you can't just cherry-pick one damaging sentence out of a 2-hour-long conversation. If someone makes an admission, but also gives a bunch of excuses or explanations right then and there, the court needs to hear all of it to judge fairly. It stops people from taking things completely out of context.
And now for the real courtroom drama. Just because the prosecution has an admission, it is not a guaranteed win. There are incredibly powerful rules that can get an admission thrown right out of court. We're entering the exclusion zone. The first major roadblock is the coercion test. The law is crystal clear on this point. An admission has to be voluntary. If it was forced out of someone through any kind of improper pressure, it is not getting into evidence, period. And the law is super specific about what coercion means. We're talking about violence, threats of violence, or this thing called oppressive conduct, which can be really intense psychological pressure. Now, here is the most important part. The court isn't asking if the confession is true. It actually doesn't matter at this stage. The entire focus is on stopping authorities from using these unfair methods. It's about protecting rights, not just chasing facts. So improper conduct is one way to get a confession tossed, but it's not the only way. The next big hurdle, and this one only applies in criminal cases, is all about the reliability of the admission itself. Can we actually trust what was said? So here's how it works. First, the defense team has to raise a red flag. They have to point to the circumstances and argue that they make the confession seem untrustworthy. As soon as they do that,
the burden of proof completely flips. Now it's on the prosecution to prove to the judge that it was unlikely those circumstances would cause someone to make a false confession.
So what kind of circumstances are we talking about? Well, the court looks at two main things. First, the person themselves, their age, their personality, their education level, any disabilities. And second, the questioning itself, were there threats or promises made? For instance, a confession from a very young person after hours of nonstop, intense questioning is going to get a very close look under this rule. So up to this point, we've really been focused on a person's own words being used against them. But what if someone else says something that makes you look guilty? Is it possible for their words to be treated as your admission? The answer is sometimes yes.
This gets us into a fascinating part of the law called vicarious admissions. It's this idea that because of a special relationship you have with someone else, their statements can sometimes be legally pinned on you.
The law lays out a few very specific situations for this. One is if you gave someone the authority to speak for you. Their words are now your words. Another huge one involves employees. If an employee says something related to their job, that can be used as an admission against the company. And finally, there's the common purpose rule. If you're in a conspiracy, for example, a statement from your co-conspirator that helps the plan along can be used against you, too.
You know, after running through all these different sections and rules, it might start to feel like a confusing maze of legal technicalities. But it is so much more than that. This whole complicated system is there for a very, very profound reason, at the heart of our justice system.
Ultimately, every single rule we've talked about is part of this incredible, delicate balancing act. On one side of the scale, you have the quest for truth, the need to figure out what really happened. But on the other side, you have to protect individual rights and make sure the whole process is fair. These rules are the very thing that keeps that scale in balance.
And that really leaves us with this final, massive question. These rules try to find a middle ground, but that tension is always there. In this relentless search for justice, how do we decide the exact point where protecting someone's rights becomes more important than using their own words to find the truth? There's no easy answer, and it's a question our legal system has to wrestle with every single day. Thanks for joining me.